Well, thanks for coming out. I should start by just giving you a little context. Back in 2009, the Alberta government brought in a series of laws. And when I originally read the laws, I was dumbfounded. I was in disbelief. And I initially got involved because I was asked by our Legal Education Society here in Alberta, which is the education, professional development branch for our law society, to speak at a conference. And first they asked me to review one of the laws, and then they phoned me later and said, well, can you review the second law, and then can you do the third law? And so sure. But I couldn't believe what I was reading. I worked behind the scenes with the MLAs of the day to try and convince them that these were very bad laws and misguided and they needed to change direction. And that didn't work out. And tried to convince myself that I could just turn a blind eye to all of this. You know, you get the one guy on your one shoulder saying, you got to do something to stop this. The other one, are you crazy? Don't even bother. Just make lots of money as a lawyer. This guy won out. So in 2010, September, I went on the road, and I ended up being on the road for 3 years. I spoke at 66 meetings before over 35,000 Albertans. In every small town. Some weeks I would do 6 or 7 presentations in a week, one in the early afternoon and one in the evening. So why did I do all these things? The good news is that many of the bills have since been repealed, so it wasn't an effort without results. However, the biggest, meanest, nastiest one is still there. Our new Premier, Jim Prentice, has indicated his intention to fix the property rights problem. So I thought I would use this opportunity in this audience to describe just go over the basics of what property rights are, describe the problem created by the legislation, and what I think some of the solutions are. So let's get going. And some of this is going to be overlapping themes from some of the things you've heard from some of the other speakers. And understand I'm a lawyer. I normally every day represent landowners from across this province in a wide variety of disputes involving oil companies, municipalities, government, other people. So I'm going to give this analysis largely from a legal perspective, but also from a policy and historical perspective. The first thing we all need to be absolutely clear in our mind is that there is fair amount of certainty about what at law property rights are. Property rights are known as have a bundle of rights, and they have 3 key components. The first right that you have when you have property rights in things is exclusive possession. It's yours. I own my pickup truck that's in the parking lot. Don Rigney can't take it. I can let him take it, but it's mine. I own my land. It's really complicated, as you'll see in a minute. The second right you have is exploitation. That's the term that's evolved from the old English, because now exploitation back then had a positive connotation, now it has a negative connotation. So it's the right to use, to change, to improve, to harvest. So if you own a quarter section of farmland, 160 acres for those of you from Ontario, in a square, block, in a township grid, different than your townships. Anyway, you have the right to leave it. You have the right to put trees on it. You have the right to plant barley, or maybe canola, or both. So having a property right in something, my truck, I can leave it parked in my driveway. I can put it in my garage and never drive it. You know, you see these old American pickers or something. Some guy brought a Mustang in 1964 and he parked it. Well, it was his. He could decide to do that. He could decide not to use it. Okay? The other thing you have is the right to alienate, the right to sell, lease, assign, gift, bequeath. So those are the 3 hallmarks, the 3 characteristics of when I say I have a property right, that's what I have. That's what the law of Canada recognizes. What can you have property rights in? I know this is very basic, but I think it's important we go over the basics. Land, minerals, leases, permits, licenses. You can sell a license. Think about licensing that Microsoft does. You actually bought a license from Microsoft, unless you've got bootleg software on your computer, right? You can sell these things. Chattels is the legal term for personal property. Cars, cattle, equipment, tools, all that stuff. Resources, grain, timber, gravel, oil, gas, coal. Abstract things like stocks and bonds, mortgages, ideas, which we protect through patents, music, novels. There's some very rich writers out there. If they could not have property rights in the Harry Potter series, she wouldn't be a multimillionaire. She has property rights in that novel. So you can have property rights in a whole broad range of things. We tend to assume when we talk about property rights, we're talking about dirt. We're talking about land. But of course, remember, we're talking about something more broad. In our system, there's a fundamental relationship between property rights and the rule of law. And we hear the rule of law thrown out all the time. I was just watching Obama, a report on President Obama giving a speech to the United Nations about 3 weeks ago about the situation in the Middle East. And you know how the guy in the newsroom at CNN, he waits for somebody to say something and then he throws it up on the screen. And then the guy's title comes up. And then another quote comes up. And the big quote that came up was, "The rule of law is not optional." So Obama was talking about the rule of law not being optional. And we all kind of nod. Well, what the heck's the rule of law? We use this term all the time. There's a relationship between the rule of law, which I'll talk about in a little bit here, and property rights. Without the rule of law, you can't have property rights, because property rights are rights that need to be enforceable, and the rule of law is about having access to independent courts, limits on government. It's about everybody being equal before the law, including the government, independent courts, as I mentioned. So rule of law is about the absence of arbitrary decisions, impartial processes, checks and balances on power, limits on government, respect for freedoms. Those are sort of elements of the rule of law. And when you don't have the rule of law, you have rule by man, which history has shown us leads to arbitrary and unfair decisions. So why are property rights important? In theory, property rights and the rule of law are the hallmarks of modern democracy. We understand that. And a market-driven economy. How do we deliver the needs for our people? We don't have a command and control economy. We have a market-driven economy. How did we find a venue for this conference? We didn't have a government bureaucracy set up a meeting room and build it and everything else. The marketplace provided this venue. In practice, respect for property rights by government adhering to the rule of law, in my view, allows us to be free, to achieve our potential, and maximize the wealth for our families and communities. Okay? That's me putting it in what I believe are practical terms. So, again, why are property rights important? Neil Ferguson was mentioned earlier. He's this very well-known Harvard economic historian. And his book, Civilization, the West and the Rest. And he went through and he tried to identify why is it that we had this great divergence in wealth over time. You know, you go back to the 1500s, this is one of his slides, and you go to the 1970s, and in the 1500s, the average Chinese person was more wealthy than the equivalent of an American person or the British. But by the 1970s, the average Briton was 10 times richer than the average Indian, even allowing for the cost of living and other factors. And by the 1970s, the average American was 20 times richer than the average Chinese. So he sought out to try and understand what caused this great divergence in wealth. And he concluded it wasn't geography. This is another one of his slides that I stole from his TED Talk. Gotta love screen capture on a computer. It saves you hours of work. And he says not geography. And here he gives the example of Germany after the war. You took a country and divided it in half, and one side gives us the Trabant, the worst car ever made, and the other the Mercedes-Benz. So it's not geography. And he went through and he said it's not imperialism, it's not an ethnicity. And he concluded that the reason for us having the great divergence in wealth throughout the last 3-4 centuries was what he calls the 6 killer apps, these 6 institutions. And much like an app on the phone, it's just a little button that you push, but behind it there's huge complexity. And one of them that he identified as key to have caused the success of the West was property rights and the rule of law. The slide just says property rights, but when he speaks he always says property rights and the rule of law. And much like an app, property rights and the rule of law are very complex. They're not simple in the effect that they have on how people conduct their affairs, how wealth is generated, how governments work, and how society governs itself. So in his analysis, property rights with the rule of law are one of the reasons that we had such success in the West until recently. So, and he also quotes Locke, and I'm somewhat of a fan of Locke. I don't agree with everything he says. Freedom is rooted in private property rights and their protection through law. You know, it's the basis of the Western model of representative government. So, what happened here in Alberta? As I mentioned at the start, 2009, 2010, the government passed a series of laws that fundamentally attacked, in my view, property rights and the rule of law. And I spent a ridiculous amount of time talking to people confidentially within government, relationships that I had, reviewing government documents, Freedom of Information Act applications, Hansard transcripts, trying to understand how the heck did this happen in, of all places, Alberta. And my short answer is the bureaucracy was empowered by then Premier Stelmach. They saw the rights that people had and the courts as obstacles to the bureaucrats' planning needs and their policy goals, and the politicians just went along with it. I'm not trying to give the elected officials a pass there, but that's where it started. So here's the 4 bills. We all know, I think, that a bill is not a law. A bill is the number gets introduced to in a legislative session, and then it has its own name, and then once it's passed into law, receives royal assent and proclamation, it's now a law. So here I am about to embark on this initiative across the province. Could you imagine if I had to do an interview on an AM radio interview and I've got a soundbite of 12 seconds and I have to use all the names? So early on I decided, even though it's not technically accurate, I would stick with the bill numbers. And the bill numbers, you can still walk up to some people in rural Alberta and say, what do you think about bills 24, 50, 19, and 36? And they'll say, they suck, right? So it was easier for people to remember the numbers than it was for the names. So that's why I always talk about the bills, although technically I should use the full act names. So the first one was Bill 24, the Carbon Capture and Storage Act. What happened with that really simply is that when you own your property, you own to the highest heavens and down to the center of the earth. You don't own to the bottom of the deepest fence post. You don't own only 6 feet. You own everything but that which is exempted. And on most titles, mines and minerals have been exempted. Water is exempted by statute. Treasure trove, which is gold and silver, is exempted and goes to Her Majesty by common law, and so on. But you own the sand and gravel, and you own the pore spaces. Well, the government of Alberta wanted to do this multi-billion-dollar carbon capture program, and there was a problem. The landowners own the pore space. No problem. Just pass a law. So Bill 24 declared the government of Alberta to be the owner of the pore space under all lands in the province, and then went on to say that no compensation is payable. So they took it and they used the right legal language to prevent compensation from being payable for this pore space. There's other places in Canada and around the world where landowners who still own their pore space actually rent out that pore space for subsurface storage of gas and other things, natural gas. Nothing's been done to change that piece of legislation, although the new Premier Jim Prentice is winding down the whole carbon capture program. But it doesn't mean, the reality is landowners had property in the pore space, the government took it and passed a law to make sure you couldn't get compensation. Bill 50 was the Electric Statutes Amendment Act, and what essentially it did was, before, if a major transmission line was to go across your property, there had to be a public hearing process, And the company that was going to build this major transmission line had to demonstrate there was a public need. Okay? The government removed the requirement for a needs assessment, took the decision about whether the line was going to be built from the public hearing room and moved it to the cabinet room, because they're all electrical engineers and rocket scientists. And as a result, according to major industry groups that were supposedly wanting these power lines, massive power lines, over $16 billion of power lines were approved. Some have been completed. Others are currently under construction. If you drive out in the countryside, you'll see them. That went through no needs assessment, and landowners had no say. The government has since repealed Bill 50, but 4 of the 5 major power lines got through the process before they repealed it. Bill 19, the Land Assembly Project Area Act, this allowed the provincial cabinet to freeze your land indefinitely while the planners in transportation and infrastructure made decisions about where they wanted to build infrastructure, such as ring roads and other things. I fully support planning. Just clear, I'm not with Lauren Gunter. If you heard him this morning, I believe that we should have the laws of expropriation. If we need to build a highway, the government should have the power to expropriate your land, but you must be fairly compensated and in a timely, efficient way. So I'm not against having expropriation powers and expropriation processes. But what this legislation did was it allowed the government to freeze your land for over 30 years. There's a cabinet order on your title. The cabinet order freezing your land had to be served on the municipality. They were not allowed to approve any development changes, even the addition of a garage to your home or expansion of your business while that cabinet order was there. And it had to be served on your bank. How do you think your bank would feel about that at mortgage renewal time? Right? And how are you going to sell your land? How are you going to sell your land? You know, you get some great new job opportunity in Ottawa, so you want to put your house up for sale, and you can't sell it because anybody who goes to buy it, there's this freeze order. And I complained about this and said this is fundamentally unfair. If you want to freeze my land for 35 or 40 years, the moment you make that decision, you've got to give me a way out. You've got to give me a chance to get out and fairly compensated. And that's all I asked. And boy, did I get called names and everything else. And finally, it was actually Premier Redford right after she got elected as Premier. She said, we're going to fix this. We're going to put a mechanism in. So as soon as we issue the freeze order, the landowner has the right to declare expropriation and go to Land Compensation Board and get compensation. I'm like, really? I had to spend 2 years traveling to the province to get that finally? So that one's fixed. Bill 36. This one's the gorilla. And it's really hard to believe. It's the biggest challenge I had when I was giving these talks was getting people to understand that this is real. So Bill 36, new powers for the provincial cabinet to rescind water licenses, oil leases, development rights, grazing leases, timber agreements, gravel approvals, livestock permits, you name it. The cabinet has the power to do what it wants whenever it wants in a way that they've never had these powers before. Some of the politicians would say, oh, we've always had these powers. That's not true. And then they put in this thing called a Henry VIII clause. I thought it was some teenage drinking game or something. I didn't even know that there was a thing called Henry VIII clauses, and you're going to find out what a Henry VIII clause is in a minute. So, Bill 36. But before I go into Bill 36, I just want to circle back for a minute. We talked about what are property rights. 3 legal rights. Exclusive possession, the right to use. That's very important, the right to use, and the right to alienate. Now, let's use an example here just to understand, to be clear in our minds about a few things. This is a picture of a dairy farm somewhere in Alberta. That would be a family dairy farm. Probably a couple generations running a farm that size. So mom and dad, and one of the daughters with her family, and one of the boys with their family and grandkids, and there are 3 houses in the yard, and they got 2 hired men with their family, and they all run this farm. And they have title to that land where that dairy farm is. They have a land title. Gives them property rights. They also, to operate that dairy farm, they need what's called a confined feeding operation approval in Alberta. And it's issued by what's called the Natural Resources Conservation Board. So you can't run a dairy farm in Alberta, or a feedlot, or a hog barn, or a chicken barn, without a CFO approval. And you, from a practical point of view, if you can't water the cattle, they die. There will be no milk, so you need a water license. And, or you need water, and in Alberta, if you divert over a certain amount of water, you have to get a license under the Water Act, okay? These latter two documents, the CFO approval, the water license, are what Bill 36 calls statutory consents. So these are permissions to do things that are granted by statute, statutory consents. Imagine for a minute that, because the government kept saying, oh, Mr. Wilson's wrong. We're not going to take your land title. Just as a footnote, the first version of the law actually said they could extinguish land titles. They took that out. I never even thought. It also said they could extinguish, by effect, they could extinguish marriage licenses, death certificates. I thought that would be really cool. Extinguish a death certificate. That would be really neat. You know, you don't need cryogenics or nothing. You just get the government to declare you're not dead and then you come back to life. Because governments can do anything. They just have to say it. It makes it happen. But think for a minute. So the government says, don't worry, Mr. Dairy Farmer and all your extended family. We're not going to take your land title. Don't worry about it. And then I say, but we are taking your CFO approval. Is it any different for that farmer if they take this CFO approval? He's got to get rid of all his cattle. He's out of business. He's bankrupt. How's he going to pay the loan payments on all that equipment? The dairy parlor in there, the milker's probably robotic, probably costs $1.2 million. Okay? What I'm trying to get at is, you don't have to take the land title to fundamentally mess with people. If you can take this away or that away arbitrarily, there's no protections for this. I don't care that you can't take my land title, or if you take my land title, I get to go to the Land Compensation Board. It's about the protections on these things. Similar example, packing plant. You can do the same thing with forestry, all these other things. To run a packing plant, you need the land title, you need a municipal development permit, you need an industrial approval from Alberta Environment in our province, and you need a water license. If they can take any of these away arbitrarily, and they don't do anything to the land title, the owners of that packing plant are going to go, oh, thank God they didn't take the land title. They're not going to care. Who's going to want the title? Follow me? So, government action taking away your right to use things is just as consequential as the government taking your land title. And the same thing applies for forestry, oil and gas, mining, pulp and paper, all of the drivers of our economy. You can't engage in wealth creation, employ people, make things better in Alberta and in many places unless you have these statutory consents. They're very, very, very important. So what Bill 36 is about, it's a new central planning law. The Cabinet will now plan what you can and can't do on every acre of private and public land in the province. That's what the law does. It gives the Cabinet complete legal control over what you can and can't do in a way that has never happened before in Alberta, and I would submit a parliamentary democracy. The government's own, I used to, on my talks through rural Alberta, most of the slides I put up were actually the government slides, and I'm going to show you, I think, just two of them here. Because how do you believe this? Like, you guys are probably looking at me already. This guy's crazy. It just doesn't make sense. They call it a paradigm shift, a new, bold, and transformative way of doing business, a completely new approach to managing land and achieving economic, environmental, and social objectives. That's the government's version of what this is all about. So here's the purposes section. The purposes of the Act are to provide a means by which government can give direction and provide leadership in identifying the objectives of the province of Alberta, including economic, environmental, and social objectives. A lot of people think this is about environment. What's the first word they used? Economic. To provide a means to plan for the future, recognizing the need to manage activity, and they define activity means everything, literally, look up the definition of activity, it means everything and anything, to meet the reasonably foreseeable needs of current and future generations of Alberta. So now the Cabinet is going to do this plan for the whole province from the Cabinet room. They've got spare time because they don't have to worry about power lines anymore because they repealed Bill 50. lots of spare time. They're going to manage activities to meet the needs of reasonably foreseeable needs of current and future generations of Albertans. How have we traditionally done that? Through the market. With regulations. I am not a person who believes there should be no regulations. In fact, the reason we can say you own land is because of regulation under the Land Titles Act. So I support regulations, just not crazy ones. So they got this idea that there was this great crisis in Alberta, that the current systems aren't working. The slides I would put up where they justify this caused the greatest reaction from the audience, because it was the government's words, not mine. That this is what they need to do. And then listen, to create legislation and policy that enables sustainable development by taking account of and responding to the cumulative effect of human endeavor and other events. So from the cabinet room, I'm just feeling so relieved. I don't have to worry about a thing. My wife and I have 4 kids. We don't have to make any decisions anymore because these guys are on it. From the cabinet room, they're going to take account and respond to the cumulative effects of human endeavor. I don't think they've developed a computer yet that can do this. Watson, IBM, won Jeopardy or whatever the other year. So this is what they want to do. So this is one of their slides, and there's a few people in the audience here today who I know I recognize from some of the talks I gave across the province a few years ago. And this would be the typical way I'd put one of their slides up, so they could tell it wasn't my slide. I'd always put it on an angle. So they want to shift away from our legislative framework that was focused on preventing adverse effect, preventing harm. The whole idea is you could do whatever you wanted on your land as long as you didn't harm things, right? You could do what you're doing on your land as long as you didn't pollute the river going through, as long as you didn't harm your neighbor. That was the paradigm. That's the market property rights paradigm. And they wanted to shift it to focus on achieving desired outcomes. And guess who's going to set the outcomes? The all-knowing, all-powerful cabinet. Which, I don't care how smart they are, history has shown no one person possesses that ability to anticipate the complex needs of a society, and that's why market economies lead to more prosperity and health and happiness than other systems. So these are some of the key offending provisions that I'm going to suggest to you that Premier Prentice should immediately repeal when the legislature resumes to honor his promise to restore property rights in Alberta. Section 11 allows Cabinet, through the Cabinet room, to rescind existing rights, including development rights, resource extraction rights, mining rights, water licenses, grazing leases, and every other dispositions, approvals, permits issued by the Alberta government. Remember back to that dairy farm example? These are the key things that we need to run our economy and for people to engage in entrepreneurial business meeting the needs of society. Section 19 restricts the right to compensation if government approvals, water license, grazing leases, subdivision approvals, etc. are amended or rescinded. Section 13, no right to the courts unless the cabinet lets you. 15.1, binding on municipalities and all Albertans and every decision maker, every regulatory body in the province that has to abide by the regional plan. They commit a jurisdictional error if they don't comply with the regional plan from the cabinet. Section 15.3, no right to make a claim against the government for anything harm done to you because of it. Section 15.4, the role and the authority of courts is restricted by the Act. And Section 17.4, Bill 36 trumps all other acts. It is the paramount law of Alberta. So, I know that's hard to believe, so I'm going to force you to see a couple of the sections. My apologies in advance. Look at this. Implementing a regional plan. So the cabinet, this is in the section about cabinet powers, may, through a regional plan, manage whatever is necessary to achieve or maintain an objective or policy, including managing all or part of a cause of an effect, or those matters that affect or might affect the economy, social objectives, the environment, human health, safety, species, or any element of them. Is this the type of language you would expect to see in a Canadian province? The cabinet's going to do all this stuff. They can't. History has proven it. It's not a question of them not wanting to or being disingenuous. Life doesn't work that way. History has shown us that. Eastern Europe. So here's another one of their, and Like these guys, it was almost like playing t-ball at times. This is another one of their slides. Look at the expression they put at the top. I didn't bring up Russia, they did. I was like, really? And so I would say to an audience, as I say to you, so through this regional plan, they could say, we no longer want that dairy farm there. And they don't have to take the title. They'll just take the CFO approval away. They'll rescind it under Section 11. Okay? Well, that's outrageous. Well, maybe they'd want to do it for a feedlot. Well, that's outrageous. This is their original slide. Is a feedlot okay here? This is Southern Alberta, by the way. So it shows that's exactly what they're thinking. Did you follow me? This is their slide. I didn't touch it. All I did was turn it on its side a bit. So here's the section that gives them all the power. For the purpose of achieving and maintaining an objective or policy of regional plan may, and only the cabinet can make a regional plan, may, blah, 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 rescind a statutory consent. So they can rescind it. Now, let me give you an analogy to help you understand how dramatic these somewhat, for a lawyer, simple words are. Imagine you leave here tomorrow and you're driving to the airport and you're obeying all the traffic laws and the vehicle you're driving complies with all the traffic safety requirements. And a police officer pulls you over and he asks you for your license, your driver's license. And he says to you, I am rescinding your driver's license. I think many of you would immediately, intuitively say, sorry, sir, but I don't think you can do that, right? You have the sense that the government just can't take something from me because he feels like it, because he doesn't like me, because he's in a bad mood. There has to be a reason. I was drunk, driving recklessly, I ran people over, I haven't renewed my license, it's suspended. You follow me? There's got to be a reason. What's the reason here?
Too much traffic.
No. Section 11, there's no qualification. They can do it. They could decide to rescind all the water licenses for lawyers who live near St. Albert. Just because they feel like it. By the way, I'm from St. Albert. If you didn't pick up on that. So, here's all the types of things they can rescind. Arbitrarily, which prior to this legislation they could never do. They could never do this before. Oil sands leases, oil and gas leases, mineral leases, water licenses, timber licenses, forestry management agreements, gravel extraction permits, grazing leases, right of entry orders from the Surface Rights Board, approvals for feedlots, dairies, fertilizer plants, meat packing plants, food processing facilities. They could actually rescind the quotas under the quota management system because it is an approval and a license issued underneath the statute. Irrigation licenses, development rights, zoning bylaws, area structure plans. You guys get the idea, right? Well, here's how it used to work. Here's an example under the Water Act, because the government will say, well, they used to say, they're not saying anything right now, thank goodness, partly because I'm not on the road saying things. This is my first talk in over a year, I think. We'll see what tomorrow brings. Under the Water Act, it says the director may, in other words, test the proposition in your mind with this example. The government's always had this power. Okay, let's test that proposition to tear things up. The director could, only the director at Alberta Environment could suspend or cancel a water license under certain circumstances. Just like that police officer can't come and just take your driver's license, right? You see the idea? So, and it was on the request of the licensee, look, I'm getting out of the dairy business, we're shutting the thing down, I don't need my water license anymore. All right? And there might be some other reason because somebody else wants that allocation and it's his brother-in-law or whatever. If the license has been issued in error, well, that makes sense. You know, if there's an emergency, public safety, that makes sense. If the guy hasn't been paying his debts to the government, well, it's questionable, whatever, it still makes sense. There's some logic to it and some element of fairness. If there's a non-performance, a serious breach of the license, you're violating the terms of your license. That's the circumstance we accept the police officer to be able to take our driver's license. And there's other ones, and so on. And then there's other provisions that say if the director, if he otherwise tries to take your water license, and it's only in a narrow set of circumstances where he can, like for an in-stream flow emergency or something like that, compensation is payable, and if you can't agree, it goes to Land Compensation Board. Okay? That's traditionally how our system has worked. When you can bank on these CFO approvals. When the new legislation came out around 2001 in Alberta for large livestock operations, and there was a downturn in the economy, I got hired by a lot of banks to give opinions on whether or not that farm could lawfully operate. Because they weren't going to finance it, because if the guy went under, they wanted to be able to sell it to another operator to keep its value, right? So, and here's the Ag Operations Practices Act. So the Natural Resources Conservation Board can cancel an approval for a dairy barn if the holder, the dairy operator, requests it, or if you've sold it and you want the name changed, or if it's been abandoned. But otherwise, there's no circumstance which the Natural Resources Conservation Board can take that approval for that dairy barn and tear it up. Follow me? Just like that police officer cannot arbitrarily pull you over and tear up your driver's license. That's how it's supposed to work in a rule of law parliamentary democracy. But that's not what this law does. It gives the cabinet unrestricted powers. And it says, anything they do under a regional plan, this is back to Land Stewardship Act, Bill 36, you have no right to sue the government. It creates no claim. All of these things are designed legally, in my view, to defeat an argument that you could potentially bring a claim to the Land Compensation Board under the Expropriation Act. I tried to do an analysis to make it work. I can't. I've written up these analyses to show that there's no compensation. A request to court for review of any relief of any kind, so you can't bring, if the cabinet does something to you through a regional plan, you can't go to court. The lawyers in the room will recognize this as a privative clause. They're not highly unusual by themselves, but when you combine it with all the other provisions, the paramountcy provision in Section 13, which I'll show you in a minute, you start to realize how dangerous this is. This is Section 13. A regional plan is an expression of the public policy of the Government of Alberta, therefore the Lieutenant Governor and Council has exclusive and final jurisdiction over its contents. For many of you that, you say, whatever. Here's the deal. When you're in law school and you take administrative law, you're taught that policy decisions are not reviewable by courts. Let me give you a simple example. You live in a small town. You want to start, you have a furniture store on Main Street. There's a business across the road that has a furniture store. Happens to be owned by the mayor. I'm making these facts up just so in case I've always worried. Somebody goes, that's happening in my town. And you decide you're going to put up one of these really fancy LED light signs. Well, the mayor's, he doesn't like that. That's not good because he doesn't want to spend the money on one of those signs. So if the town council decide to pass a sign bylaw as a policy decision, you can't have that reviewed. But let's say the bylaw is already in place and you comply with the bylaw and there's no reason why they shouldn't approve your sign, and the only reason they don't is the mayor uses his influence to have the planners turn down your sign, that decision is reviewable. So policy decisions are not reviewable by the court. If the City of Calgary decides to do a no-smoking bylaw, that's a policy decision. If they apply it unfairly, how they execute the decision-making, the decisions that they execute, if they're done arbitrarily or unfairly, those are reviewable by the courts. Okay? So what they did was they said, how can we stop the courts from reviewing cabinet decisions under regional plans? And so a lawyer said, well, if you declare them to be public policy, then they're beyond the jurisdiction of the court. So they declared every decision of canceling and rescinding things to be a policy decision. Okay? And I could put up the slide, I have it. If you doubt that that's their intention, They thought they were so right about this that they had it in their PowerPoint presentation, that this provision is designed to protect cabinet decisions from review by courts. Designed to protect cabinet decisions from review by courts. And I can't remember the other phraseology, but they make it sound like the courts are the latest biker gang to show up in town, and Albertans need to be protected from them. Okay, so they, Morris Seifeling, who was the Assistant Deputy Minister and Stewardship Commissioner, spoke once at the same event I was at. And when some of the lawyers in the audience said, "Why did you do that?" And he said, the government believes that we should have political accountability, not accountability to the courts. Courts aren't elected. We want political accountability. If Albertans don't like the decisions the cabinets make, they should deal with that at the ballot box and not at the courthouse. And then he said, "Next question." The guy put up his hand. The lawyer put up his hand, and he said, "Yeah, what's your question?" He goes, "When's the next election?" In other words, it didn't go over well. So these are not accidental provisions. They're deliberate. They had it in their slides. They believed that this is the way it needs to be done because the crisis facing Alberta was so urgent. We're growing so fast that the old ways of doing things, they would say, and still have up on their website, no longer work. So we need this bold, new, innovative approach of central planning and everything out of the cabinet, and we need these powers to achieve goals. Obviously, this offends the rule of law. There's the paramountcy provision. Compensation. The Act plays this snake and ladders, smoke and mirrors game with compensation. I would be very pleased if, in fact, it was the case, by the cabinet rescinding that dairy farm's approval, that I could find compensation. Because there's a really good chance, given the work that I do and my reputation and my name recognition, that the first dairy farmer that happens to is going to come through my door. And I don't want to tell him or her there's nothing I can do for them. Right? So I analyzed this legislation to see if there's a mechanism in there. And I could trace through all their compensation provisions, and they don't lead to anything. They're nonsense. Henry VIII just showed up. So let's just take a walk back in time real quick. Go back to the Statute of Proclamations of 1549. So there's this fella, King Henry VIII, and, oops, that didn't work. I have a slide that has a whole bunch more stuff on it. Well, I'll just go to my notes then. That's why you should always print off your presentation. And when I was on the road, I never had to go to paper because I'd done it so many times I had it memorized. Anyway, Henry VIII brought in this the Statute of Proclamation, where he sought to usurp the role of Parliament and move decision-making and law-making powers from the Parliament to the King. And it was one of the reasons that he had such a bad reputation, and there's nursery rhymes and everything else about the guy. There's other reasons too, of course. But it's one of the reasons. So, here we go. Anyway, so under a Henry VIII clause, the whole idea is that rather than have the elected officials sitting in the legislature in the public setting through the lawmaking process make laws, you shift the lawmaking power into the executive suite, the Premier's office, the cabinet, something like that. And to show you that I'm not making this Henry VIII clause thing up, because again, the first time I heard it, I thought, what the heck's that all about? This is a picture of Lord Chief Justice and President of the Court of England and Wales. And he's the equivalent of our Chief Justice of our Supreme Court of Canada over in England. And boy, am I ever glad we don't have to wear those wigs. I don't know if I'd be a lawyer, actually. But anyway, he gave a speech in 2010. And in his speech, it was in London, some big event, he said his deepest concern at the moment is directed to the increased use of what are described as Henry VIII clauses. This is the equivalent of the Chief Justice of the highest court of England speaking in 2010. You can be sure that when these clauses are introduced, they will always be said to be necessary. Necessity is the justification for every infringement of human liberty. It is the argument of tyrants. This is not some extreme ideological guy. This is the Lord Chief Justice of England talking about the VIII clauses. Well, why am I telling you about this? That was the slide I was looking for. Because Bill 36 has a Henry VIII clause. Why not? Give themselves every other power. So the Cabinet may, if you read it in context, through regional plan may make law on any matter within the legislative authority of the legislature. So they can make law from the Cabinet room. They can amend the Water Act. They can amend the Surface Rights Act. They can enact new legislation through the Cabinet room. The first paper I wrote on this, and it's still on the internet, I said this was unconstitutional. I was wrong. I had no idea. It was I came across a paper done by Professor Kwasniak at the University of Calgary Law School. And she called this provision draconian. And she was going on about these Henry VIII clauses. And I was like, what is it? And then I started researching it. Australia Law Reform Commission just did a big paper on Henry VIII clauses. Because where they're starting to creep in is in all this terrorism legislation, where it's giving lawmaking powers to the executive branch, right? And concerns being expressed about it and how far it's going. So now the Cabinet can not only do whatever it wants to you, it can change law from the Cabinet room. Then they brought out their regulations. And this shows you again the paradigm. Normally when you don't comply with something, because I deal with a lot of enforcement matters, the government will issue an order and tell you to prepare a plan as to how you're going to fix your problem and bring yourself into compliance. That's how we used to do things. Now, once the Cabinet approves the regional plan, if the designated minister determines that a trigger or limit are exceeded, because they're going to set all these targets and limits in these regional plans for everything from air emissions to tourism visits to viewscapes to all kinds of stuff. An appropriate official or officials in the designated minister government department must initiate a management response consistent with the framework. So you don't develop the solution for how you're going to solve the problem that you've caused, assuming it's a valid problem. The bureaucrats are going to come up with the plan for how you're going to bring your dairy barn or your forestry operation or your oil sands mine into compliance with the Cabinet's wishes. Because, the second most smartest group, and I'm being a little unfair here and a little exaggerated to illustrate my point, second to the Cabinet, while all-knowing, can plan for all the future affairs and everything we need, because my wife and I don't have to worry about it anymore, and they got it covered. The next smartest group is going to be the bureaucracy, because they can't trust you to prepare the plan for their approval. What if they get it wrong? What if they come up with some plan for something and they just get it completely wrong? The person responsible, that's you, shall comply with the lawful directions of the official. So you see the mindset change? The government's got this. It kind of reminds me of that. I think it's a Geico commercial, and the guy's all confident because he bought good insurance, and there's a juggler with chainsaws, and he says to his wife, puts his coffee down, he's going to jump in, and he's, I got this. That's what, it's the Cabinet and the bureaucracy are like, oh, we got this. We got this. We can run this economy. We don't need the market. We don't need property rights. We don't need the rule of law. We got this. So, Lawrence Solomon, from the National Post, found out about this and researched it, and he said, called it Tyranny of the North. Alberta passes draconian laws abolishing property rights. He talks about Venezuela director Hugo Chavez. I made the mistake in an early interview when I was critical of the laws. Darcy Henn from the Calgary Herald phoned me up, and he says, so what do you think of Bill 19? And me, I should have told my inside voice to shut up. I said, Hugo Chavez has arrived at the Alberta legislature. And sure enough, front page of the next day's paper, didn't go over so well. But I said it, I stand by it. So he talks about, he says, Venezuela's Hugo Chavez was in the news this week for brashly announcing expropriation of mineral rights of the citizens, for the citizens of the country, of this country. We don't seize property that way in our democracy. We seize it silently, Solomon writes. And in plain sight, as seen in the province of Alberta, which so deftly passed stealth legislation 2 years ago that most Albertans are only now discovering, the government's ambitious take over their property rights. And he says, Alberta now allows the Cabinet to, quote, manage what is necessary, you saw that section earlier, to take into effective human endeavor. Alberta Cabinet has given itself the most sweeping central planning powers in the Western world, tyrannical powers that would leave a mere Hugo Chavez dumbstruck. This is real. Why did I become so concerned about this? There's a whole bunch of reasons. But my wife and I have 4 kids. When I started, the oldest was 16, I think. He's now 20. I just thought, is this the kind of place I want my kids to grow up in? Where if they want anything done, they got to go seek favor of the elected official in Edmonton? That they don't have these basic rights that I grew up with? Because these types of powers are going to encourage favor-seeking behavior. If they're talking about rescinding your dairy farm approval, there's nothing I can do as a lawyer to help you. There's nothing the property rights advocate, despite his great intentions and skill, can do to help you. You're hooped. You may as well get your checkbook out and go make a big donation or do whatever's necessary to save your family farm. You see what I'm getting at? History's taught us this is a bad idea. You don't give government this kind of powers at the same time remove all the checks and balances.
What did the bank say about this?
Questions after, but thanks. It takes us back to a time when there was no rule of law. Alberta, as I point out, is now a province where the rule of cabinet is supreme. A lot of people would ask me, so I put this slide up, you guys mostly know the answer, so I'll just touch on it quickly. How is it that this could even happen? Well, of course, we don't have constitutional protections in our Charter for property rights. And under our Constitution Act of 1867, our provinces are responsible for property rights in civil matters. That's why we have Land Titles Act, Water Act, Municipal Government Act, Public Lands Act. The point is that throughout our history as a country and as a province, provincial governments have included protections in their laws so that citizens' property and rights cannot be taken arbitrarily, compensation must be paid, and they provide for protections through the courts. But that's obviously no longer true in Alberta. So Rachel Alterman, who spoke at the Property Rights Conference in Ottawa in 2013 or 12? 12, thank you. She's done this. She's a professor from Israel. She's worked in the United States as well. She did this an international analysis where she compared and studied 13 countries, mostly developed countries, for how they treat compensation for land use restrictions by government. Because obviously Bill 36 is all about land use restrictions by government. That's what it's all about, in a nutshell. And what she found was that on a scale, and this is her slide, which I stole. Thank you, Rachel. I'll send her a thank you, because I thought it was so good. Some countries offer no compensation rights except for physical expropriation. So unless they take that title, remember the example, number 1 was the land title? If the government takes your land title, you go to Land Compensation Board. You're good to go. Expropriation, you right to compensation. But if they do anything less than that, you get no compensation over here. So they just restrict your use. They take away your CFO approval, or they say you can't do this on your land anymore, even though you still have the title and so on. And then there's other countries where they have extensive compensation rights. We're even down zoning or restricting your use of your land for a public beneficial purpose, to create a viewscape, to create a wildland area transition. Anything is for a public benefit. If your use is restricted for the greater good, you're entitled to compensation. So she analyzed these 13 countries to see where they fit. For those of you who haven't seen it, guess where we are. No compensation rights other than pure expropriation, the UK, Canada, Australia, France, and Greece. Moderate and somewhat vague. Sometimes they compensate if they restrict your use, and sometimes they don't. Finland, Austria, the US, and the special, she always calls the special case of Oregon. The reason that touches my heart in a very strange way is I got summoned to a meeting with the Minister of State and Resource Development, Mel Knight, who was overseeing this legislation. And I said to him in this meeting, and I realized I was set up because when I got out, there was all the cameras and the media. They wanted this photo op with me with the minister to say they were listening. Anyway, the things you learned. And I turned to him and I said, and there was senior advisors from the Premier's office in the room and everything else. And I turned to him and I said, Minister, I said, I'm not trying to be provocative here, but I have to ask you. I looked around. I thought, has this been tried somewhere that I didn't know about? Because I said everywhere I searched for this whole central planning concept, all my search results kept bringing up Eastern Europe. So if I missed something, and he said, well, actually, we modeled it after Oregon. And I was like, oh, I didn't know about that. And then I hear Rachel, she talks about this. Oregon tried this, and Oregon is a basket case. And that's why in her analysis, she always talks about the special case of Oregon. Anyway, broad compensation rate. Here's the important point. Which countries say that if we, the state, are going to restrict your right as a landowner, as a business, to do things on your property for the greater good, we're going to compensate you. If we're going to take your land that's worth $1 million and restrict what you can do on it for the greater good, so it's only worth $300,000, you come see us and we'll pay you $700,000. Which countries do that? And we know that it's Poland, Germany, Sweden, the Netherlands, and Israel that she studied. So, going forward, here's what I think needs to happen in Alberta. I think, first of all, the government needs to immediately, as on November 27th, when the legislature resumes, or whatever the date is, they need to repeal those offending provisions of Bill 36. Giving the cabinet that power is unacceptable. Stripping the role of the courts, all of those things are dangerous and bad. They need to be repealed. You can do all kinds of planning without having those kind of powers. And the other thing, I think, because Premier Prentice has said Bill 1 is going to be about this new law to respect property rights. If Germany can do it, if Poland and Sweden and the Netherlands and Israel can do it, we can do it. And I think the government needs to bring in a law that says when a governmental decision unreasonably interferes with your use of your property and causes you economic harm, you should be compensated. Thank you very much.